raised and adjusted the time. So whoever is ready, Mr. please continue with your submissions.
Yes, my Lord, before the short adjournment, Lord Justice Arnold had raised a question about Tom Cabinet, so I thought I'd look at that next and deal with that question. It's in the bundle of authorities at tab 67, page 1829. My Lords, my Lady, this was a case concerned with an electronic book club. Tom Cabinet ran an electronic book club in which effectively it resold downloads of electronic books. And the facts and procedure and questions are summarised in the Advocate General's opinion on page 1837. AG 18. And as he describes there, it supplies online market for used ebooks, and the way it operates has changed. At present, the context of a service called a reading club, Tom Cabinet resells to individuals registered on its site ebooks it has bought either from the official distributors or from other individuals. Then at lower prices he charges, or it charges, and then it encourages individuals who bought ebooks on its site to resell them to it after they have read them, which also entitles them to credits, allowing them then to buy other books. When it buys ebooks from individuals, Tom Cabinet requires that they delete their own copy, places a digital watermark on the copies from which it sells in order to ensure that the copy is legal. So just pausing there, one can see immediately that this is a case very far away from a straightforward hyperlinking case, in that what Tom Cabinet is doing is obtaining copies of ebooks from users, uploading them to its website, and then selling download copies adjusted with watermarks to the members of the club or users of the service. The judgment picks up at page 1853, in which the question being referred was whether this activity constituted distribution, I think it was, in the context of the ebooks, but also the question of whether the right to the communication to the public was also infringed.
To be clear, that the referring court deliberately did not refer the question of communication to the public to the Court of Justice, and the Court of Justice said that actually you couldn't ignore that point and took it up for itself.
Thank you, my Lord. I stand corrected. I had not picked up that point. Anyway, be that as it may, the question of the communication to the public right was considered by the Court of Justice. And as one can see, again, they have a further description of the process at page 1859. At paragraph 24, which gives a bit more detail as to what happens. It's an ebook trader, it says. In return for payment, it offers second-hand ebooks, either purchased by Tom Cabinet or donated free of charge by members. In the latter case, those members must provide the download link in respect to the book in question and declare they have not kept a copy of the book. Tom Cabinet then uploads the ebook from the retailer's website, places its own digital watermark on it, which serves as confirmation that it's a legally acquired copy. And then there was a slight change in the pricing and so on and so forth, none of which matters for present purposes. Turning to the passage referred to by my Lord Justice Arnold at page 1866, paragraph 65. It's common ground that Tom Cabinet makes works concerned available to anyone who's registered with the Reading Club's website, personally able to access the site, etc. According to the supply of such a service must be considered to be the communication of a work within the meaning of Article 3.1 of the Directive, irrespective of whether that person avails himself of the opportunity of actually retrieving the e-book. So the provision of the opportunity to get the e-book is the act of communication. And then they move to the question of considering communication to the public. The protected words must in fact be communicated to the public. They refer to stitch and brain, and communication being directed at an indeterminate number of potential recipients. So again, the concept of the number of people forming a republic. And they then refer to previous authority on the question of what constitutes public. Paragraph 68, it's more than a certain de minimis threshold. That's about the numbers of people embraced in the concept of public. And at 69, they refer to the facts, noted that anyone can become a member. Only one copy of the work can be downloaded in the period of the use of the work as actually access the work, and the downloaded copy can only be used by that user. So that's the business about the fact that the previous owner has to delete his copy, and one copy is then sold on to the new user. At 70, they refer to the question of using specific technical means, and also failing that a new public, so public not already taken into account by the copyright holders, the authorised initial communication. And at 71, we come to the passage that my Lord referred to, where they say, in the present case, since the making available of an e-book is, as NUV and GAU have noted, generally accompanied by a user license authorising the user who has downloaded the e-book concerned only to read that e-book from his or her own equipment, it must be held that a communication such as that effected by Tom Cabinet is made to a public that was not already taken into account by the copyright holders, and therefore to a new public within the meaning of the case law cited in the preceding paragraph of the present judgment. And then they go on to conclude that that's saying, therefore there's a communication to the public. Now, pausing there, first of all, as I said at the outset, it's very different circumstances, again, from the simple hyperlinking case that we're concerned to in this appeal. This is a case in which works are being uploaded and downloaded via the provider of the service. So it's a case of content provision. Secondly, as regards the reference to the user license, in our submission, that's not, in fact, properly understood a reference to a particular license or to some arrangement between a copyright owner and the original receiver of the content. It's a very high-level, generalized reference to industry practice in relation to the sale of e-books, which is generally speaking that you're only allowed to have it for yourself and read it for yourself. So in our submission, that doesn't undercut in any way the judge's conclusion in his judgment at paragraph 107 that there's nowhere in the case is there an attempt to consider the terms of any actual copyright license applicable to the initial posting of a work on the internet. They're not considering individual scope of licenses. For example, a license or granted to a radio station that may have restrictions on linking or something of that nature, or the detail of whether someone posting a picture on a website or a photo on a website has said that it can only be made available to non-commercial linkers or something of that nature. They're talking in this passage about a very high-level judicial notice of an industry practice, which is consistent in our submission with the judge's characterization that there's no attempt to live the terms of any actual license. They're simply looking at a general industry practice in relation to e-books. And while I'm on this subject, acknowledge my lady, the Lord Justice Arnold also referred to, I think, to two of the other ECJEU authorities, which I should just mention now before I move on, which are connected to the consideration of communication to the public. One of them was Filmspieler, which is in the same bundle, at least in the same, my same bundle, at tab 74. That's page 2049. This is another case concerning communication to the public, and in this particular case they were considering a device called a Filmspieler, which is a plug-in device you put on your TV or possibly your computer that provides access to online streams of content. That's a very broad description. I'll come to how it's described in the judgment in a moment.
In this country, they're better known as Kodi devices, KOD.
Yes, that's the similar type of device, my lord, quite so. And the point about the device was that it contained within it hyperlinks to some lawful content, but also it was sold on the basis it had hyperlinks to unlawful content. And one can see that at page 2054 in the Advocate General's opinion, where they explain what the Filmspieler, he explains what the Filmspieler is. Various models of a multimedia player under the name Filmspieler. Device acts as an instrument for connecting a source of image or sound signals to a television screen. Differences in models of technical nature, operations are eventually the same. If the multimedia players are connected to the internet on the one hand, the user's screen on the other, the user is able to stream the image and sound from a web portal or website. Hardware for the media player can be brought from various suppliers. He installs an open source software, makes it possible to open files through user-friendly graphic interface via menu structures can be used by anyone. He also installed add-ons, separate software files, created by third parties, freely available on the internet, integrated into the software. Those add-ons contain hyperlinks, which if clicked, redirect the user to streaming websites controlled by third parties on which films, television series, and live sporting events can be enjoyed free of charge, with or without the authorization of rights holders. Digital content starts playing automatically when the relevant hyperlink is clicked. And then in 14 of the add-ons, they led to films, etc., without the authorization of the holders of the reproduction rights. Others led to authorized holders. Mr. Williams had no influence over the add-ins, but on his portal, as one can see, he advertises the products as never again pay for film, series, sport, as one sees in the quoted passage there. And turning to the judgment at page 2071, the court considers the dispute in the main proceedings and questions referred. Again, they set out the nature of the Filmspieler device, and they note in paragraph 16 that some of the links specifically linked to websites on which protected works are made available to internet users without the consent of copyright owners. And then turning to the consideration of the questions concerned, again, they're concerned with the question of whether what Mr. Williams is doing constitutes a communication to the public. And in considering that question, one has the familiar consideration of the principles of communication to the public, and so on, and whether there's a communication, whether there's the public. And at 31, page 2074, the court refers to the essential role played by the user. The user makes an act of communication when he intervenes in full knowledge of the consequences of action to give access to protected work to his customers, and does so in particular where in the absence of that intervention his customers would not in principle be able to enjoy the broadcast work. And they refer then to two other cases, GS Media amongst them. And then after consideration of public and communication and the specific technical means in the following paragraphs, they refer at 34 to the profit-making nature of the communication being relevant. And at 36, they again refer to the question of communication taking place that the public may access, irrespective of whether they avail themselves of that opportunity. And 37 refer to Svensson, that provision on a website of clickable links to protected works published without any access restrictions on the site affords users the first site of direct access to those works. And they say that's also the case for a multimedia player, so that's that issue in the main proceedings. Then after further discussion of the recitals and the question of communication, at 42, they summarise the position in relation to the Filmspieler player. Consequently, it must be
right. Just before you go to 42, we need to look at what they say in 41, the passage bridging the pages, where they say the intervention enabling a direct link to be established between websites broadcasting counterfeit works that purchase the marketplace, without which the purchasers would find it difficult to benefit from those protected works. So this is one of the passages where they refer to putting it the other way around, facilitation.
Yes, quite similar. I should have mentioned that passage, you're quite right. It's the, what they're pointing to is the fact that the Filmspieler, whilst providing hyperlinks, also does something over and above provision of simple hyperlinks, and it's making it much easier for users to access the protected works. And then, in light of that, consequently, it must be held the provision of the multimedia player enables, in view of the add-ons pre-installed on it, access via structured menus to links those add-ons when activated by remote control, etc., offer its users direct access to protected works without consent of copyright holders, must be regarded as an act of communication with the meaning of Article 3.1. And continuing with the reasoning, they discuss the fact it's been bought by a fairly large number of people, and at 47 they turn to the question whether the work's communicated to a new public, and refer to the previous decisions in Svensson and Bestwater, which is that the public is a public not taken into account by the copyright holders when they authorise the initial communication. And then they refer to GS Media and the importance of the consent of the holder of the copyright protected works being made freely available. And then turning to the application of that, they say at 48, clear from the judgments referred to that posting hyperlinks on a website to protected work being made freely available on another website with the consent of the copyright holders of that work does not constitute communication to the public within the meaning of Article 3.1 of the directive. In that regard, the court held that so long as the work is freely available, it must be considered that where the copyright holders of the work have consented to such communication, they've included all internet users as the public. However, such finding cannot be deduced from those judgments failing authorization, then refer obviously to GS Media. Then they refer to the GS Media, summarise the GS Media principle. The court therefore held, first of all, that where it's established that such a person knew or ought to have known that the hyperlink he posted provides access to a work illegally placed on the internet, the provision of that link constitutes communication to the public. So that's a summary of the GS Media presumption, or rather the state of knowledge that's required in GS Media, which is that the person has to know or ought to have known that the hyperlink provides access to a work illegally placed on the internet, and that then constitutes a communication to the public. And then they go on to do with the circumvention of restrictions, and in the same paragraph halfway down they turn to the question of a person posting hyperlinks for profit, which is that where it can be expected he carries out the necessary checks to ensure the works concerned is not illegally published on the internet to which those hyperlinks lead, so it must be presumed that posting has occurred with full knowledge of the protected nature and possible lack of consent on the internet by the copyright holder. And then, so far as that rebuttable presumption is not rebutted, the act of posting, etc., constitutes communication to the public within the meaning of Article 3.1. And then turning to the conclusion in the present case, common ground the sale of the Filmspieler multimedia player was made in full knowledge of the fact that the add-ons contained hyperlinks pre-installed on that player, gave access to works published illegally on the internet, advertising specifically stated, made possible in particular to watch on television screen freely and easily audiovisual material available on the internet without consent. So the court is there concluding that the films dealer made it easier it wasn't simply a case of provision of simple hyperlinks, it was easier for the purchasers who otherwise find it difficult to get access to protected works. And secondly, that it had been provided with the relevant full knowledge, which is that it was providing hyperlinks to access to protected works. So it's an example of the application of the GS Media principle. The other authority that I think was referred to was the Pirate Bay Ziggo case, which is in Bundle 1. At tab 22, page 204. This is an application for an injunction by the Dutch anti-piracy organisation, which is Stichting Brain, against the internet service providers in Holland. So effectively it's a blocking injunction type case, but the reason they were seeking the blocking injunction was in relation to the Pirate Bay, which is described in the head note as an engine for peer-to-peer file sharing. And the court concluded, in summary, that the Pirate Bay was indeed communicating works to the public, which we say is not surprising when one considers the nature of the service. There's a colourful illustration of the nature of the service at page 206 in the opinion of Advocate General Sunar in the introduction. Quoting from an Australian judge, the file being shared in the swarm is the treasure, the BitTorrent client is the ship, the torrent file is the treasure map. Pirate Bay provides treasure maps free of charge, and the tracker is the wise old man that needs to be consulted to understand the treasure map. The point being that what the Pirate Bay provided was links to, or alternatively, the files themselves are BitTorrent files, which are a set of instructions that once downloaded by a user, I'm sorry if I'm not getting this perfectly technically accurately, but once downloaded by the user, can then be used to get bits and all the little pieces of a copyright work and assemble them in one place. So that's the exercise or the nature of the service that's involved. And in relation to the holdings, the judgment starts on page 223, and on page 224 they summarise the nature of the dispute after referring to the relevant legal provisions, and at the top of page 225 they explain the way that the BitTorrent protocol works. It enables users, peers, to share files, divides files for sharing into segments, thus removing the need to rely on the central server to store those files, which lessens the burden on individual servers. And then in order to be able to share files, users must first download specific software called the BitTorrent client, not provided by the online sharing platform Pirate Bay. The BitTorrent client is the software that allows the creation of the torrent files. And then it goes on further to explain the technicalities of the way it works. People create torrent files, which are effectively instructions to finding the bits, and they're uploaded by people onto an online sharing platform such as the Pirate Bay, which then indexes them so they can be found. And then the torrent files can be downloaded onto the user's computers. Sometimes magnet links are used, which are a form. They identify the content of a torrent file and refer to it through a digital fingerprint. And the torrent files, they note in paragraph 12, offered by the Pirate Bay relate mainly to copyright protected works without rights holders having been given their consent to the operators or users of that platform to carry out the sharing acts in question. And Brain's principal request is that Ziggo and XS for all be ordered to block the domain names relating to the Pirate Bay. And the court then turns to the question of considering how the concept of communication to the public or right of communication to the public applies in this context at page 226. And they recite many of the familiar principles and authorities that we have seen previously, and the customary elements of communication and so on and so forth. And page 228, coming to the findings in the relevant context, they refer to the Filmspieler case and conclude from that at 34 that, as a rule, any act by which a user with full knowledge of the relevant facts provides its clients with access to protected works constitutes an act of communication for purposes of Article 3.1. And it's not disputed that the Pirate Bay provides, makes available to use their platform copyright works whenever the users choose. And then they conclude, after further discussion of that, which is the intervention in full knowledge of the consequences of conduct by indexing torrent files, at 37, the view must therefore be taken that the operators of the online sharing platform, Pirate Bay, by making that platform available and managing it, provide their users access to works concerned, therefore playing a central role in making the works in question available. And then finally, they can't be considered as making mere provision of physical facilities, and they go on to describe the indexing process and so on and so forth, and therefore that constitutes a communication to the public. They consider the question of new public at paragraphs 44 and 45, and unsurprisingly come to the conclusion that there must be a communication to the new public, since it's linking to works for which no consent has been given, no authorization of the rights holders, and so on and so forth. So it's another illustration of the application of principles. The conclusion in our submission is not at all surprising, in that it's again an entirely different case from hyperlinking. There's a complicated technical process that the Pirate Bay is integral to, which provides a means for users to share copyright works, and therefore this is not a case in which Pirate Bay is simply hyperlinking to anything. It's providing, it's part of an infrastructure and a technical system that allows the sharing of copyright works. So, my lords, coming back, my lords, my lady, coming back to the judgment, therefore, I had departed or gone off to deal with those cases off paragraph 107, where I was referring to the judge's approach to the question of whether there was any consideration of an actual copyright license. And the reasons I have submitted, Tom Cabinet is not properly understood an example of consideration of an actual copyright license, but rather a very generalized view of an industry practice, which is consistent with the judge's formulation 107. The fifth point the judge makes at page 108, page 145 of the core bundle, is concerning the presumption in GS Media, again, with which we don't take issue with the judge's formulation of the presumption in GS Media. It's the way that he applied it, or rather we would say did not apply it, when it came to the question of the category 2 stations that we suggest is the area that he fell into error. But I'll come on to that, I hope, fairly shortly. Just for completeness, it's worth noting that he summarized the paragraph 108, where he summarizes the presumption, is not quite complete, but he explains what the nature of the presumption is and the nature of the knowledge required in GS Media at paragraph 109.7 on page 146. In the second half of that paragraph, when he says, however, if all the defendant has done is put up a link to the first posting of the kind in GS Media, then that act of communication is only an infringement if the person posting the link knew or ought to have known that the original posting was without any consent. This follows from striking the balance between the rights of copyright owner, freedom of expression, and then at 8, in the case in which the initial communication was without consent, and the knowledge of the person posting the link is material, the persons acting for financial gain will be presumed to have the requisite knowledge that can call evidence to rebut that presumption. In other words, they can call evidence to rebut the presumption that they knew that the posting was to illegal or unauthorised content. If they rebut that presumption, there's then a further question to be considered, which is whether they ought to have known, which involves consideration of what they did do and what else they could have done, and whether it would have made any difference to their state of knowledge, whether they would have discovered that the item in question was unauthorised or illegally posted. So I now turn to heading 4 of the my submissions, which is the sample stations. And the judge began this process, or the assessment, the application of the principles of communication to the public to the facts, at page 148, paragraph 120, where he discusses the Tunein service. And we have addressed this in our skeleton starting first of all at section C, where we say that the judge made at this point an erroneous distinction in relation to the Tunein service, in that he drew a distinction which he said was material to the issue as to the difference between what he says Tunein does and what a internet search engine does, such as Google or Bing or DuckDuckGo, or whatever the case may be. And he starts by noting that this was Tunein's position, that it was, as far as relevant to the right to communication to the public, providing the same service as a conventional internet search engine. And we submit that he failed to give, in considering this, a satisfactory answer to the question that we put forward, which was, how is what Tunein is doing relevantly different to any other provider of hyperlinks, whether that is a major commercial search engine or an amateur blogger providing lists of hyperlinks of his or her favourite radio stations. The points of similarity are clear. All such providers of hyperlinks contribute to the sound operation of the internet by enabling dissemination of information. They enable the public to navigate to content that they wish to find on the internet. And therefore, the starting point is to recognise that hyperlinking is an activity that's recognised to serve valuable public policies. It is intrinsically useful and should not be unduly restricted or deterred. And we give the example that any major search engine is likely to have a UK-facing website targeted to the UK audience and to index and provide hyperlinks to quite possibly billions of websites and copyright works around the world using a very large searchable database. Now, the claimants didn't suggest, and the judge doesn't suggest, that a search engine would infringe by linking two such station streams, which of course can be done simply through a standard search engine. Any of the radio stations that we're concerned with can be found, and you can listen to them unrestricted simply by using Bing or Google or whatever as your preferred search engine to do that. What occurs when one finds a radio station in that way and links to it is the same process as occurs when you do it through Tunein. Tunein provides a hyperlink to the stream. When you click on the hyperlink, the stream connects directly from the radio station server to the user without passing through the Tunein website. That is the way that it works. There's a difference in appearance. It is true that if a conventional search engine is used, usually there will be no framing. So you will go to Google.
Can I ask you this question, Mr.
Yes,
Howe? If there's no difference from using a certain, why don't users, sorry, I seem to be getting feedback. I don't know why that is. I think someone is confused. Let me try and start again. If there's no difference from a search engine, why do we need Tunein at all? Why don't users simply use search engines? And in connection with that, how is it that your clients make money from advertising if there's no difference from a search engine?
Well, my lord, the answer to that is as follows. The users could use, if they wanted to, a standard search engine or other methods of searching the internet to find any of the radio stations that they can find on Tunein. But obviously, what Tunein provides as a platform is effectively a specialized form of search engine. Its particular service it provides in this connection is that it concentrates on radio stations and therefore provides users with a more convenient way of locating radio stations that they want. But this is a very different position in our submission from, for example, something like Filmspieler, where what Filmspieler was doing was locating and providing served up on a plate links to streams that would otherwise be difficult to find, and in relation to which it knew when it was selling its device that they connected to a large quantity of unauthorized material. So, my lord, there is no difference in either in technical operation or in substance between, we say, and using an ordinary search engine to find any of these radio stations and using a platform such as Tunein. Tunein is...
I think you're accepting, are you not, that there is a distinction in that the user friendliness of the Tunein service is attractive to users, which is why users use it, and that enables your clients to profit by selling them advertising.
Well, my lord, the same is true, though, of course, of ordinary search engines, in that the search engines also provide advertising. They provide a convenient way for users to obtain and locate more general content on the internet. But they still operate in the same way. They make advertising through the process of providing that service. What we are effectively...
Is the difference, Mr. Howe, not that in what you said about obscure content? I mean, you provide links to 100,000 radio stations all over the world, playing particular artists or particular music. Now, you could search on Google to your heart's content, but you could not find Elton John playing on Slovakian national radio without Tunein. And so you are actually creating a completely different facility for the user who wants to find content in remote places, which would otherwise just not be done through Google or Bing or any of the usual search engines. And that is a distinction and makes it, doesn't it, look almost indistinguishable from Filmspieler?
Well, my lord, with respect, no, it's not a substantial distinction in that by using search terms on Google, you could find very easily every radio station in Slovakia or Romania or whatever the case may be. You could find genres of radio stations in particular territories. All those things can be done without difficulty. As to metadata, it is true that Tunein collects some additional metadata through its AIR software add-on, but on the other hand, metadata is routinely published by radio stations alongside their streams. Indeed, one can see it if you go onto any radio station site. There will usually be, frequently, an album image and a statement of what song is playing. And there's a reason for that, which there's the evidence about it at trial, which is that the rights holders themselves prefer the radio stations to provide the metadata alongside their streams for a number of reasons, including that it makes monitoring of the distribution of royalties and so on and so forth easier. So the metadata is not particularly unusual. Tunein provides some additional functionality, but it's not different in substance to the type of service provided by Google or Bing or any other search engine.
I thought your argument was your answer to that was going to be slightly different. I thought what you were going to say is, yes, we do package it up in an attractive way and make it easier for people to find Elton John singing on Slovakian national radio, as the Master of Royals says, but that's not the communication which has to be authorised. That's the box, that's the packaging, and we can make that as nice as we want and as attractive as we want. But the actual, none of that is protected by copyright law. What is protected is the communication of the author's work. And when you're focusing on that, then your hyperlink is exactly the same as everybody else's hyperlink. And it doesn't become different because it's dressed up in all sorts of fancy things that make it more attractive for people to buy. I thought that was your point.
Well, my lady, it is. That is the point. And that's what I mean by we don't act in a way that is relevantly different to any other provider of hyperlinks, whether it is a blogger listing his or her 100 favourite classical stations from around the world, or whether it is Google with searches of jazz stations in Slovakia, or whatever the case may be. We provide a more specialised and easier way for people to find radio stations, if they're interested in finding radio stations, but nothing that we provide is any different to what can be accessed freely by anyone else with an internet connection. So it's not a case of us circumventing paywalls or providing obscure links to unknown file locker websites where pirated works might be hidden or something of that nature. We are simply providing an easier way for people who are interested in listening to radio to find radio stations they want to listen to. It's just that simple. We don't do anything different, relevantly different in that respect to Google.
Can I try and make this my last question? Lord Hoffman said in a slightly different context, follow the money. That will tell you the answer. Isn't the fact that people pay for this through the advertising quite a good litmus test?
Well, my lord, not if by that question, my lord, you mean that because someone is making money, it must follow that there's an infringement or a use of an intellectual property right. In my submission, that's a non sequitur. There are a number of contexts in which people can perfectly properly make money without making any use of any restricted copyright. And a good example is any search engine you care to name makes money from advertising searches because what they provide, the service they provide, is the searching. We provide the same. We provide a service that enables people to search. That is a valuable service that our users appreciate and they like it, but it doesn't follow from that at all. And the fact that the Tunein service is able to produce adverts alongside that, that there's any use of intellectual property in providing that service. It's quite distinct from the stream, which is the service provided by the radio station, which can be accessed by anybody with an internet connection.
Can I ask this, Mr. Howe? I mean, presumably Slovakian, I'm sorry to victimize Slovakia, but it's just a place with 5 million population. And on Slovakian radio, presumably when they play Elton John, they pay a royalty for the 5 million people that it's being broadcast to, but not to the several hundred million people in the world, thousands of millions of people in the world, because the rights owner doesn't imagine that those people are going to listen to Slovakian radio. And what your programme provides, what your whatever. Let's not give it a name, otherwise it's forecasting an outcome. But what you provide is the ability for people to listen to music and content which the rights owner is not being paid for all over the world. And in particular, just to take the Slovakian example, there are probably very few Slovakians living in the UK, and they might listen to Slovakian radio, but no person who's not Slovakian living in the UK would ever listen to Slovakian radio unless a packaged mechanism was provided by which they could do so. Now, what I don't understand at the moment is why, just in natural logic, without looking at all the cases we've looked at, a rights owner should not be paid if, for example, instead of the audience of Slovakian radio listening to Elton John, which is, say, 1,000 people, another 1 million people listen to it in the UK, listen to Elton John in the UK through that mechanism packaged by you. I mean, surely that is a very different process from the completely random process of people searching for Slovakian radio in England, which they don't do. So, I mean, it's just, to me, it sounds logical that Elton John should get his royalties for the extra 1 million people listening in England.
Well, there are two responses I have to that proposition. The first is that, my Lord, with respect, it's not correct that we provide access to anything that isn't already freely available. So we don't provide any access to Slovakian radio unless...
No, Mr. Hutt, don't misunderstand my question. That's not what I asked you. I said, through Tunein, people can access the content of Elton John on Slovakian radio. They can access it by searching for Slovakian radio. My question is, why, standing back from all the authorities, if by packaging it in the way you do, 1 million people in the UK listen to Elton John through Slovakian radio, which they wouldn't have done otherwise, the rights holder shouldn't expect to receive its royalty because it arises through the packaging you've undertaken?
Well, again, I was dealing with the questions in turn. The first is, as I say, that, I'm sorry if I misunderstood the point your Lordship was making, that what Tunein is doing is a platform that enables hyperlinks, or provides hyperlinks to streams that are freely available, and nothing else for the purposes of this appeal. The second point is, my Lord, as regards listeners, well, I suppose it would be possible that 1 million people might listen to Slovakian radio in the UK. It's conceivable. If that were to occur, then no doubt the rights holders could consider whether to take action against the Slovakian radio station to ensure that there was geo-blocking, so that its internet link was not freely available to everybody outside the relevant territory, if that were to be a significant matter of concern for the rights owners. So that is the source for solving such a problem were it to occur. But at the moment, your Lordship's considering a possibility that seems to be completely theoretical rather than realistic.
Well, the reason why it's not theoretical is because it doesn't matter if it's 1 million or 1. You pay your royalty, Slovakian radio pays its royalty based on the number of times it plays and the number of people that are expected to listen. And if one more listens in a country where it wasn't expected, and in this case it's many, many countries where it wasn't expected, why shouldn't the royalty holder be paid, whether it's 1 or 1 million? I mean, obviously the assessment may be difficult. May only be a few who get to Slovakian radio in Britain to hear Elton John, but it may be many or whatever. It might be a minute part of a cent, but that doesn't matter, does it? That's not the point.
Well, my Lord, one shouldn't assume necessarily that the Slovakian radio won't be paying royalties on Tunein listeners. because many licenses include, and obviously this depends on the circumstances, but many licenses include royalties based on listenership numbers. And listenership numbers on streams can be easily tracked and provided, because a radio station knows if someone has linked to a stream, so they can provide reliable figures for usage depending on their own particular configuration and setup. So it's not the case that one can assume that listeners in the UK contributing to the listenership numbers of a Slovakian radio station are not leading to an increase in the payment of royalties by the Slovakian radio station. It depends on the license terms.
If that were, I mean, I didn't know that, but if you're right and that were the common and normal practice, surely that would be an answer to this case. Because legitimate radio stations always pay royalties for streaming, and you only provide the hyperlink that allows streaming to take place outside the particular territory, then otherwise, if this case succeeded, the rights owners would get double money.
Well, my lord, no, because the position is that the claimant's contention in this case is that there's an infringing communication to the public when a UK listener uses Tunein to find, for this example, the Slovakian radio station and listens to it. Their case is not based on the proposition that they thereby necessarily suffer loss. They simply say that that is an infringement, and that's the principle and the issue that we've been concerned with. If the additional listener led to an increase in royalties being paid by the radio station in Slovakia, it wouldn't be a defence to the argument, if it were right, that there's an infringing act of communication in the UK just simply because someone connects the station. It would be a reason why there might have to be an accounting for damages in relation to that infringement, but it wouldn't affect the issue with which we have been concerned, which is the legal argument that there's an infringement in itself. So that's not an area probably that's the reason why that hasn't been extensively explored in evidence, because we're currently concerned with the trial of liability in relation to certain sample stations, not issues of quantum at this point.
I mean, I see that, and that all sounds very sensible to me, but I mean, surely the money, I mean, as my lord said, money is the most important thing here, isn't it? I mean, nobody denies that rights holders are entitled to be paid a royalty for content that is distributed. And so if you don't look at the money, you may not be getting the right answer.
Well, my lord, anyway, I can only proceed on the issues currently before the court, which is we have a trial on liability, which has included the issue of whether the acts in question constitute a communication to the public.
But to be clear, as I understand it, and you will correct me if I've got the wrong end of the stick, it was not your client's case at trial that there was no infringement because, in fact, all users in the UK were listening to streams that were licensed through the mechanism of tracking listeners by the radio stations and royalties being accounted for in respect of all such UK users. That was not the client's case, was it?
Of course not, my lord. We were not advancing that case. And as I say, even if there had been a payment of royalties in respect of the UK user, it wouldn't be an answer, if it were the case, to a claim that the act itself was an infringing act. It would only come into play when one came to consider quantum. So for that reason, neither side has really engaged in any detail with that.
Is that the case even in those territories where there's only a remuneration right and no right to stop the broadcast? It just seems bizarre.
Well, my lady, it's the answer. The issue turns on whether the act is an infringing act at this stage on the question of liability. Quantum is, as I say, not within the scope of the current trial.
But it seems that this this question of whether it's an infringing act depends on this idea of whether it's a new public. And the question of whether it's a new public depends on whether the public was in the contemplation of the author, of the owner of the copyright, when they authorised the original stream. But you're not saying, or it's not your case, that the question of whether the Slovakian listener in the UK was in the contemplation, or whatever the phrase is, of the rights holder when it was authorising the Slovakian radio station. That question is not affected by the fact that the license they have, they say, well, if somebody listens through Tunein in the UK, you have to pay us an extra 10p or whatever. And it just seems so completely divorced from reality. But there we are.
Well, my lady, we are at this stage applying, and the judge below was, of course, also attempting to apply the principles in the CJEU cases as to how the undetermined with an act of communication has taken place. And it's our case in relation to the vast majority of the streams concerned that Svensson is directly on point and indeed binding authority on this issue, which is that if what you are providing is a hyperlink to to content that is freely available on the internet, then there is no new public and therefore no act of communication. Because the answer to my ladyship's question that the Court of Justice gave about what was the public in contemplation of the copyright owner in relation to works posted on the internet that were freely available with the consent of the copyright owner was that the public in contemplation was everyone who had access to the internet and could potentially navigate to the website and access it.
Can I just ask a question on that? Because, as I expect you well know, one of the alternative analyses, which some suggest is gaining ground sub silentio in the more recent case law, is that of the implied license. Now, what would your submission be if one analyses this through the prism of the concept of an implied license?
Well, my lord, one has to be a little bit careful about that. One could analyse it through the concept of an implied license, but that is that would require departing from the Svensson ratio, which we say is very clear, which is that the court in Svensson deemed, if one puts it on an implied license basis, that the implied license extended to everyone in the world who had access to an internet connection, in the case of a hyperlink connecting to freely available material, and leaving aside circumvention and the other types of issues that don't arise here. Therefore, the position is that anyone, we say on the basis of Svensson, and subject to the qualification in GS Media, which we'll come to in relation to Category 2 stations, anyone with an internet connection, anyone is entitled, without committing a communication to the public, to post a hyperlink to another freely available website. And that includes, and indeed embraces precisely, what Tunein does with its platform. It provides hyperlinks to freely available websites. It therefore falls squarely within the Court of Justice ratio in Svensson. On the same theme, if I can just follow this through a little bit, the learned judge, when considering this aspect of the matter, suggested that there was an analogy between having a book in a library without an index as compared to being able to look into an index and find it. He drew that analogy as part of this reasoning in paragraph 57 of the judgment. At page 135, where he referred to this concept at the end of that paragraph. It's 135 of the core bundle. He said, considering Svensson, aside from access restrictions, the reasoning treats availability as an all or nothing idea, but the world's not really like that. A book in a large library is available in one sense, but it might never be read if it's not correctly indexed. The act of correctly indexing such a book is a way of making it available to anyone who did not have the time or inclination to walk down every shelf, looking at every book in turn. That's why it can make sense to regard linking as an act of making something available. Now, pausing there, the judge is not at that point making a direct comparison or analogy with what Tunein does, but to the extent that one's making an analogy with the library and an index, Tunein is not a good example. This is not a case in which we have a library with no index. We have a library with a very substantial index, indeed a whole series of competing indexes in the form of the readily available and free search engines that have, on which one can easily find, with a few clicks and a few searches, any of the radio stations to which Tunein also connects. The closer analogy would be that Tunein is, as it were, simply a specialist sub-index within the library. So we're not concerned with books that can't be found because you have to walk down every shelf. We're just concerned with having a slightly more convenient sub-index that deals with scientific works or whatever analogy one wants to draw.
So I suppose, Mr. Howe, your answer to my earlier point is that all that looks through the lens of the pre-internet world, when rights owners were only concerned with terrestrial broadcasting through radio waves, and as soon as you stream your radio service, that is a completely inappropriate approach.
Yes, well, my lord, it doesn't work in relation to communication to the public by using hyperlinks.
Well, I mean, the point I was putting to you was the merits point, that the rights owner is entitled to be paid because he's paying Slovakian radio to distribute the service to Slovakians. But once you're live streaming it and it's available by a link to anybody in the world, you would say, well, that's not what he's paying for. He's paying for anybody who has the link to Slovakian radio anywhere in the world, because that's what the internet provides. And you say a good thing too.
Well, yes, that's correct, my lord. The internet is global, and therefore there are methods by which one can, if you consider it worthwhile, restrict access to particular territories. Geo-blocking is a fairly common technique. If it's a matter of concern to a rights holder, they can take steps to require geo-blocking or take other measures to limit geographical access to particular websites. It's not uncommon and it can be done, and indeed it's done by Tunein in relation to certain stations when they request it. Tunein can also geo-block stations on its own site, on its own service if it chooses to do so. But stations themselves can also exercise the same function. So, well, the reason why the court approached the matter in Svensson is precisely because of that, because there are ways in which one can restrict access if you choose to do so. The finding of the court was if you choose not to restrict access so that the website is freely available to anyone who can access it, there is no new public, because it's intrinsic in the provision of the content on the internet that anyone can hyperlink to it. On the same topic, my lords and lady, I was going to refer briefly as well to some of the usage data, just so you can have a picture of what the evidence was before the court. Although I accept that the data itself is doesn't answer the question of principle, but it may be useful for the court to see in relation to the sample stations what the data was. In the supplementary bundle at (43) and 44, which starts on page 410 of the PDF in the supplementary bundle.
Sorry, could you give me that page number again, Mr.
Yes, Arnold, it's page 410, 410 of the supplementary bundle. You should have there a table.
Yes, I've got it.
And this was dealing, these tables, which are over 3 years, 2017 to 2016 to 2018, were just setting out the average daily listeners of the various sample stations and breaking them down by the location of the listeners. I should just mention, just at the start, there's a heading for Alexa listeners. Those are the ones who are listening, obviously, through the Alexa smart speaker. They're in a slightly separate category because wherever you listen through Alexa, it doesn't identify precisely where the person is listening. If they're listening through Alexa, they count it as being in California. So they're separated out because they don't show, they're neutral in terms of geographical indication. But there we are, that was the evidence. Anyway, looking at the pattern, there's also some charts I'll come to, and it's in the same part in the next tab. But as one can see, in relation to the UK stations, which are the first category 1 stations, all marked 1 in the left-hand column, music radio stations licensed in the UK, the percentage of UK listeners versus global listeners is, generally speaking, very high. The lowest is at the 31%. The larger listening, Kiss and Hits Radio, is at 99 up in the 90s, the first few of them. And then the similar figures broken down by in-country and out-of-country are then shown. But as one can see for the category 2 stations, which are not licensed in the UK or elsewhere, was the terminology we used, the UK listeners are very small in number generally, in absolute numbers, but also predominantly not a substantial proportion of the listening, except it appears in relation to the Bangladeshi station, but then we're talking about 8 out of 20 in that year. The next couple of pages, 411 and 412, show the same figures for the following years, and then the charts, which provide a visual representation of the same figures, or similar figures, provide a breakdown of the listening pattern for each of the 3 years of average daily listeners. And in relation to the category 1 stations, which are the first few pages, Heart London, Smooth London, etc., one can see that there's a strong predominance of listening in the UK. Smooth has slightly more in 2018 of out-country listening, but the pattern is similar in relation to all of them. And then the category 2 stations start on page 416. One can see that the UK numbers in relation to the category 2 stations, it starts with Radio Dudulanga, page 416. They're very small numbers anyway, and therefore probably not very useful. One can see they're tiny numbers of people. Similarly, in relation to Radio Leutzburg, XFM Malta, again, similar. There's quite a lot of out-country listening on those, but very little in the UK. And the same pattern goes through with Capital Country and Gaku, Dreistad, and so on and so forth. And just when casting an eye along the charts, one can see how the pattern works. So we are not in the region of 1 million people tuning into, at least on the basis of sample stations, tuning into an obscure Slovakian station to listen to Elton John. The pattern is...
Can you just clarify
Yes.
These figures at page 410, this is people listening through Tunein to these stations.
Yes, that's right.
So what does it mean they're not listening in the UK? I thought we were only talking about people listening in the UK.
Well, my lady, these figures provide, so one can see the pattern of usage. These figures break down the listeners by UK listeners, in-country listeners, whatever the country of that station is, and then also Alexa listeners and other country listeners. So the purpose of this is to show that, for example, in relation, or to give the figures in relation to, for example, the Category 2 stations, which are foreign stations, or the Category 3 stations, which start with Sky Radio Hits, for example.
Well, just looking at the Kazakhstan GAKU one.
Yes.
So there was one person listening through a hyperlink provided by Tunein. One person listened in the UK to that, but Tunein in Kazakhstan provided 24 Kazakhstani people listening to GAKU FM in Kazakhstan. Is that right?
That's right, yes. And then following that through, the in-country, if one looks at GAKU, just to explain what these figures show, average daily listeners in 2016, there was an average of 1 in the UK through Tunein. There was an average of 24 in Kazakhstan, that's in-country, because that's what in-country means in that context, and then 1 Alexa on average, and then other country listeners, so everyone apart from the UK, or in-country, or Kazakhstan, in other words, there was an average of 7 in relation to that, other people from around the world using the Tunein platform.
Can I ask about the Alexa listeners? If I say to my Alexa, play GAKU radio, will it automatically go through Tunein?
Well, I have to take instructions on that. There was a point. There are different providers of radio station services on Alexa. Tunein has been a provider of links to them, but you can also choose other providers depending on how you configure your Alexa. But you can, if one asks for a radio station.
Because when you say to Tunein, to Alexa, which I have done, play Radio 4, you have to say Radio 4 from the BBC, otherwise it doesn't work. So but if you say Radio GAKU FM, do you have to say from Tunein in order to get it, or could you get it automatically? Well, maybe we can all try it, Mr.
Well, my lord, I can't give you a precise answer to that. We do know from the evidence.
My lady's shaking her head, which perhaps indicates that she doesn't have an Alexa, but yes.
Well, I'm not going to give evidence, but about it, I have occasionally heard an Alexa say provided by Tunein, but I don't know whether that is invariable or not. But it is the case, clearly, from the evidence that we do have, that you can access the Tunein platform and thereby be provided effectively hyperlinks to the streams through Alexa. Whether that remains...
The figures wouldn't make it conclusive because they're not very large in most cases. So that's why I'm asking that. Anyway, if you can find out, let me know, otherwise it's not important.
Yes, and there are also other options, and there may be other radio station providers, such as the BBC, that prefer you to link directly to, or to work through their interface. Sorry, I shouldn't say link to it, because they all link to the same place, but work through their interface in order to access BBC stations. I can't provide a precise answer. I can take instructions and see if I can locate some evidence about it. There may have been something about it. Anyways, that example, that sets out, by way of illustration, the type of pattern of listening, which one can see that in-country listening predominates, particularly in relation to the UK stations. There's some other country listening. In relation to the sample stations, the numbers were generally extremely small for the UK. That doesn't necessarily affect the principle of the issue of whether something is a communication to the public in the UK or not, but it does provide some of the background to the way that the Tunein service is used in practice by its users. By the same token, while we're in the supplementary bundle, there was also evidence on the subject of comparing the way that Tunein works to other search engines. There was evidence about that in the form of screenshots, which you'll find in the supplementary bundle at tab 31 and onwards. Perhaps I should start by way of illustration with the previous tab.
Page numbers, please, Mr.
Yes, Lord. I'll have a page number for you in a moment. It is at page 339, which is tab 30, and this was just for comparison purposes, screenshots showing the process of browsing on Tunein for example, classic FM or other radio stations as compared with searching online for the same radio stations or similar radio stations. Page 339, there's an incognito tab. That's just to clear the cache so that the process of searching is carried out against a clean slate and without any accumulated cookies on the computer that was used for these purposes. And then the next page, page 340, locating an index station on the Tunein website, performing a text search. The text search is classic FM. And then that search then throws up, as one sees, a series of possible results on page 341. Classic FM in the UK. Then there's Classic FM 97.3 and several other classic stations with a similar name or the same name underneath that. Then navigating to the presentation page on the Tunein platform, one has on page 342. And one can see that's the page that you go to. And then on page 343, there's the play button in the middle of the page and also at the bottom. And then you can play the stream from there. And what's happening in that process is that's a hyperlink to the Classic FM stream. And the stream comes directly from the radio station's website to the user. It's in the way of ordinary hyperlinks. There's a similar process carried out in relation to the app, but we don't need to it comes to very similar results over the following pages. And then by way of comparison at 347, there's a tab dealing with the search, browsing for an online radio station. Google, although other search engines obviously could produce similar results. And at 348, the searches for radio stations which produce a number of drop-down menus such as radio stations UK, London, online, numbers near me, on Alexa, etc. At 349, the search is done for radio stations which produces a number of different providers of links to radio stations, as one can see, internetradio.uk.com, Internet Radio, Radio Map, EU, UK, London, and so on and so forth. And onto the following page, similar providers including a radio player, fixed radio, and then there's BBC under that as one of the searches that comes up. The searcher then clicks on the Heart Radio London link, which brings you on page 352 to the Heart station, and then to playing the one can click on the listen button, and then you have a radio player that pops out from the browser, as one can see over the following pages, 354. A similar exercise was carried out on page 356 and onwards. For a more generic search, for example, classic classical music radio, which is similar in type to the yes. This is just a general generic search for classical music radio, and one can see the search result then produces through Google a series of little cards at the top, which are links, visual links, hyperlinks to the various radio stations that you can then click on and go to, Venice, BBC Three, etc., etc. On the right-hand side, there is a little right-hand arrow which shows there are further results. You just scroll off to the right of the screen, further cards for radio stations produced by that search. Underneath that, you then have on the next page the typical search results, classical music, etc., classical FM. You can then click on classical FM, and that takes you on the next page to the station page, where you can then click on the play button, and you'll then have the stream playing through over the following pages, and also want to put that into a separate radio player if you choose to do so. Similarly, searching for Classic FM by name, so equivalent to the Classic FM search that was done on the Tunein platform, appears on the following page 363. And one can see that searching for Classic FM usually brings up Classic FM. You can then navigate directly to the website, which is, again, not surprising. So the reason for showing that is we say that that evidence supports what we have intended from the start, which is that both general search engines and Tunein are providing, so far as is relevant, the same thing, which is to say a method for locating, if you choose to do so, radio stations anywhere that have freely available links to which you can then connect.
Mr. Howe, would that be a convenient moment to take a short break?
Yes, Lord.
Should we just say 5 minutes and resume at 3:26?
Yes, Lord.
We've got Lord Justice Arnold just
Yeah, I'm here.
waiting for Lady Justice Rose. Yes, we seem not to have Lady Justice Rose. Just hang on a couple of seconds. Very good. We do now have Lady Justice Rose. Can you hear us?
Yes, I can.
Very good. Mr. Howe, please continue your submissions.
Yes, my Lord, I was just about to move on to category 3, having set the scene for that, but before I do so, I just wanted to pick up on a couple of points from before the short break. The first is, I think I said that the Alexa listeners were counted as being in California. In fact, I've been corrected, they're counted as being in Seattle. There we are, it's Washington rather than California. The same point applies. Secondly, in relation to the Alexa position, I understand that you can use Tunein to access radio stations through Alexa, but there are also other device partners, they're called, who may provide a similar service to different radio stations or the same ones, as the case may be. The third point is in relation to advertising and the question of money, which was raised by the court before the short adjournment. There is one point I should just make clear, which is that the case for the respondents is presented as a zero or even negative sum gain for rights holders. One finds that most clearly in paragraph 8, for example, of the respondent skeleton, which is in the core bundle at page 77. Where the case is put this way, or the argument is put this way in relation to the banner advertising and the pre-roll. And it said that, in the second part of that paragraph, it's a striking feature that TI's pre-roll ads play instead of the pre-roll ads that would have been served by the station if the user had accessed the stream directly from the station's own website. Thus, TI is making money at the expense of the station, and thus is the station is licensed by copyright owners on the basis of revenue-based royalty at the expense of those copyright owners. Well, that's, in our submission, a non sequitur and not an accurate depiction of the position. The starting factual contention on the evidence is correct, which is that Tunein plays a pre-roll before you connect to the station stream. Once the pre-roll is finished, you connect to the stream at whatever point it is, halfway through a song, in the middle of a news bulletin, in the middle of an advert on the radio station, whatever the case may be. You simply connect to the stream that is rolling out from the radio station at the moment that the pre-roll ends. It's also correct that if the radio station itself provides a pre-roll advert, and of course, by no means all of them do, then the Tunein pre-roll will replace the one that you would have obtained had you navigated to the radio station and connected to the stream that way, because the website for the radio station is set up to pre-roll when a connection comes through that way, but it will be, you'll hear instead the Tunein pre-roll. But it doesn't follow from that that there's any reduction in advertising revenue either for the station or hence any reduction in revenue for the rights holders, because, of course, against any replacement of pre-roll advertising by Tunein, one has to be set the fact that a station is on Tunein may increase its listenership. And indeed, there's evidence in the bundles numbers before the course as well that, for example, one of the German radio stations that was removed from Tunein strenuously objected and asked to be put back on, because for many stations they find being on Tunein is a convenient way of providing their service and maximising their listener numbers in their standard audience.
Mr. Howe, am I right in saying that there is no financial settlement between radio stations and Tunein, or is there either way?
There is in relation to some, my lord. With some radio stations, Tunein has, and again this is addressed in the evidence, a partner relationship or a broadcasting agreement, or a partner agreement rather, which includes a sharing of revenue in relation to advertising revenue produced by Tunein from that radio station. And therefore, to the extent that, again, it all depends on the licensing arrangement between the radio station and the rights holders, but if and to the extent the accounting to the rights holders is based on advertising revenue, and clearly some of them are, or general revenue, percentage of revenue, then the rights holders will benefit from the radio station's share of that revenue as well. But what one can't say, as the respondents seek to do, is that the effect is that that Tunein is profiting at the expense of either the radio stations or the copyright owners. On the contrary, one would assume that if the radio stations are rational actors, then they wish to be on Tunein because they consider it will make them better off rather than worse off.
Can it be said that in every case the radio station consents to being on Tunein?
No, my lord, but in the great majority of cases it can. And I can explain that by reference to the sign-on process, which I'll come on to in due course. I'll come on to it in the right context, which is in relation to the judge's findings about Category 2. But just by way of brief preview, the process by which Tunein started was effectively really as many search engines start, which is by categorizing and indexing freely available radio stations. So in its early days, it was simply categorizing them and providing links to them without any particular interaction with the radio stations. And that continued up to 2011. In 2011, Tunein decided it needed to tighten up and change its procedures for various reasons. And so it instituted, shortly after that, what's called a new station sign-on form, at which point it required radio stations to add themselves if they wanted to be added. In addition, it also subsequently introduced a separate form, which was a station update form for stations that were on the site, wanted to update any of their details, and they then contacted Tunein and updated their details. So the position is there, at the end of that process, there are a very large number of station updates, and also from a certain point, Tunein required all stations who wanted to be added to add themselves, to come to Tunein and add themselves or enter a new update station form. But the result is that there may be some stations dating from prior to 2011 that have not either added themselves or been in contact with Tunein to enter into an update station form, a station update form. But I'll show you the evidence on it. It's quite brief in due course. However, any station, of course, that doesn't want to be on Tunein can contact and ask to be removed, and will be removed if it requests it. So on the question of advertising, it is simplistic and not supported by the evidence to say that there's any loss to rights holders from a station being on Tunein. One would assume that stations are on Tunein because they want to be there and they consider it to be in their commercial interest to do so, given that they can always ask to be removed. And a very large number of them have asked to be on the station, and we have evidence of certainly one of them protesting loudly when it was taken off, and complaints in relation to removals and so on and so forth. But what one cannot say is that there's necessarily any loss in revenue to either the stations or to the rights holders. And indeed, the evidence doesn't deal with it, but it may be the other way round. It's a non sequitur suggests it's only one way though. Coming therefore to category 3, this is addressed by the judge at page 152 of the core bundle in his judgment from paragraphs 132 through to 142. And the first thing the judge needed to address was an issue in relation to the effect of, or how one interpolated the concept of deemed consent or anticipated consent of a copyright owner who places a copyright work on the internet voluntarily with the slightly different position in relation to many sound recordings, which is that many radio stations operate under a statutory licensing system where there's no license as such, there's simply a statutory equitable remuneration structure, which is commonplace in many jurisdictions, that allows radio stations to make use of sound recordings and pay an equitable remuneration for their performance. And he addressed that in paragraph 132, we say correctly, at least in relation to this, which is question to be answered in relation to whether works in category 3 have already been the subject of acts of communication prior intervention of Tunein. My answer to that question is yes. This, in effect, treats category 3 as if the relevant consent exists. And therefore, in other words, he treats the category 3 stations, correctly we say, as a starting point, as being equivalent to cases where content had been lawfully placed on the internet or placed on the internet, posted on the internet with the consent of the copyright owner. And we say it is correct to start with that starting point, because otherwise the Svensson principle becomes extremely difficult to operate in a sensible way, because, for example, there are many occasions on which content may be lawfully placed on the internet, posted on the internet, without the consent of the copyright owner, including, for example, in relation to the well-known exceptions such as comment on current affairs, teaching, research, criticism or review, and so on and so forth, contained in Article 5 of the Information Society Directive. That being so, and starting from the proposition that people should be able to hyperlink to material that is lawfully placed on the internet, it is correct, we say, to start with the proposition that stations that are lawfully operating, whether with the license or under a statutory regime, are in the same equivalent position for the purpose of this analysis. That being so, in our submission, the answer to the category 3 stations becomes extremely straightforward. They are, in our submission, 4 square within the Svensson principle, and the judge should so have found. The category 3 stations, which are stations operating lawfully in their relevant territories, have provided links to these streams that are freely available to anybody with access to the internet. That being so, there is no new public when Tunein provides a hyperlink to any one of those stations. It therefore follows that Svensson is squarely on point with all category 3 stations, and indeed is the binding authority in relation to that, and the judge should therefore have found that there was no communication to the public in relation to any of the category 3 stations, because they were operating lawfully, freely available, and there was no new public in providing a hyperlink to them. That then brings me to the category 2 stations, and there's been quite a lot of detail has been put on this in our skeleton and in response. And in preparing for my submissions, it occurred to me that I could quite possibly simplify the issue in relation to the category 2 stations. These are, of course, I say of course, they're stations that it was being argued were not operating lawfully anywhere. Now, in order to understand where we say the error in relation to category 2 stations, one has first to appreciate that the trial was a trial by reference to sample stations and what the purpose of having a trial in that way was. The trial proceeded by way of sample stations. Sorry, I should pause there for a moment and deal with the judge's first point in relation to category 2 stations, which is paragraph 144 of his judgment at page 154. His first reason for saying that category 2 stations were communicating to the public was that starting from category 3, it seems to be a simple approach is legitimate. Category 2 stations cannot be in a better position than category 3, and therefore they must be there must be a communication to the public from those. Well, clearly, if the judge is incorrect about category 3, then that point falls away. One then needs to turn to consider whether the category 3 amount of communication to the public, because it was argued they were not operating lawfully in their relevant jurisdictions. Now, the starting point, as I say, is that there was a trial directed by reference to sample stations, and the reason for selecting sample stations in these various categories was to make the factual issues manageable for the parties in the court. I've mentioned that there are a very large number of stations on the Tunein platform. It therefore would have been unworkable to engage in arguments about what checks had been made or what Tunein's state of knowledge was in relation to 100,000 or so stations. The reason for selecting the sample stations was enable the court to make certain decisions of principle on issues of law, but then also, really by way of illustrative purposes, to make decisions about the individual sample stations on the facts, which could then possibly by analogy or otherwise be used as a basis for further findings in due course. And one finds the CMC order on this in the supplemental bundle at page, it's tab 11, page 115. And the relevant parts of this order at the CCNC, one finds on page 116 to 118. The 116 point, paragraph 4 is the split trial between issues of liability and quantum, and then directions for the trial of liability are then given. And at paragraph 9, trial of the claim in relation to issues of liability will proceed by way of determination of the issues by reference to a sample as follows, and then the 4 different categories of sample stations are set out, and provision is made for identifying those. And then at sub 393, trial of issues in relation to the radio stations, directions set out in manual will be limited to the sample stations and the sample recordings. You can ignore for these purposes the sample recordings. There was also an exercise where certain sample recordings were identified. And then, until further order, determination of any issues in relation to sample stations shall apply only in respect of those sample stations. Following determination, parties shall have permission to apply for further directions as to scope and effect, etc. So, a sensible, obviously, case management order to focus the factual exercise on the sample stations and to limit those findings in relation to sample stations. Now, with that in mind, one then turns to what the judge was considering under category 2. What the judge needed to consider under category 2 was, first of all, whether these were indeed, each of these sample stations were indeed operating unlawfully, either without a license or outside a statutory scheme, in relation to the respective territories in which they operated. Secondly, if there was a finding to that effect, he then needed to consider the GS in relation to each of the sample stations. And as to that, as I mentioned earlier in his judgment, we say correctly summarised it as there's only an infringement applying the GS media principle if the person posting a link to unlawful material knew or ought to have known that the original posting was without any consent, or unlawful as the case may be, and persons acting for financial gain will be presumed to have the requisite knowledge that we can call evidence to rebut that presumption. So what the judge therefore should have done is, first of all, in relation to each of the Category 2 stations, decided whether or not those stations were in fact operating unlawfully, as was being contended, there being a dispute about that. Secondly, he then needs to decide whether Tunein actually knew that the Category 2 station in question was operating unlawfully, the onus being at that stage, on presumption being that Tunein did know, and that Tunein needed to adduce evidence to say that it didn't. Thirdly, he then needs to consider that if Tunein did not know that the station was operating unlawfully, whether in the circumstances Tunein ought to have known that the station was operating unlawfully. And this latter question would involve considering, in relation to each of the Category 2 stations, what inquiries Tunein had made about that station in order to determine its status of whether it was operating lawfully, whether those inquiries were sufficient or insufficient, and if so, why, and whether if Tunein had made further inquiries, which it didn't make, it would have made any difference. So those are the steps that needed to be undertaken in relation to each of the Category 2 stations to resolve the factual issues about those stations before the court. The difficulty with this section in the learned judge's judgment, which is from paragraphs 143 through to 160, is that he didn't do that at all. He didn't make the relevant findings in relation to the Category 2 stations. He instead made findings or devoted himself to evidence in general terms about how Tunein conducted its investigations of the stations and established whether the stations had given warranties or not. What he didn't do is focus on the Category 2 stations and make the necessary findings in order to reach a conclusion on them. And taking the stages in turn, as a starting point, earlier on in the judgment, at page 148, on the question of whether the Category 2 stations were or were not operating lawfully or unlawfully under the local regime, he concluded that in fact he couldn't resolve that question. At paragraph 117 of the judgment, which starts in fairness at paragraph 115, when he's discussing the Category 2 stations, page 147. He explains they divide into two classes. One is the capital FN Bangladesh and urban 96.5 Nigeria. They're states with exclusive rights regimes akin to the UK system. And there was a point about the licensing body in Nigeria. But in relation to those two, he's satisfied that neither capital FN nor urban FN has a relevant license. So he considers those two and makes findings. But in relation to the other stations, 116, which are Canada, country 104, Gaku in Kazakhstan, Luxembourg, Dudelanga, and Letzeburg, Malta, XFN, and Montenegro City Radio. He notes the claimants were contending they should be treated as unlicensed Category 2 rather than Category 3. But that's because the specifics of the relevant remuneration scheme is not yet set up and running in the relevant state, also because no remuneration has been paid. There's no detailed evidence about the laws of those states or how those schemes are supposed to work. Claimants contend on the evidence I can infer they're unlicensed, but Tunein to call evidence they were licensed. Tunein contends it's not open to claimants to take this point in this way. Claimants don't agree, and he then resolves, or rather decides that he can't resolve that. Says if he had to decide on a pleading point to find in favour of Tunein, having regard to the terminology. However, bearing in mind this is a test case based on sample stations, deciding on pleading points is not sensible. Express my conclusion for the second class on either alternative as the facts. Simply this: either the stations are acting within the relevant regime or they are not. If they're not, they're in the same as the first class in Category 2. If they are, they're in the same as Category 3. If the outcomes of Category 2 and 3 differ, then no relief could be granted at this stage relating to those particular stations, but that's a small price to pay. If it matters, the true facts of those stations can be resolved on the other issues relating to any other tens of thousands of stations not chosen samples. So at the stage are the Category 2 stations operating lawfully or unlawfully? He concluded in relation to capital FM and urban that he could decide that those were operating unlawfully, but in relation to the others, he concluded he couldn't resolve that issue. At which point it should have been apparent, we suggest, that it wasn't possible to then proceed and decide the next stages of the process, which is to make findings as to whether Tunein knew that those stations were operating unlawfully. By definition, that inquiry couldn't take place because it hadn't been determined that they were operating unlawfully, that being a matter in dispute. Nor could he then go on to the next stage and decide if Tunein did not know they were operating unlawfully, whether they should have known, because by definition he hadn't been able to decide whether they were operating lawfully or unlawfully in the first place. That's in relation to all apart from the capital FM Bangladesh and urban 96.5 Nigeria. In relation to all of the stations, however, he didn't then go on to determine the question of actual knowledge, whether Tunein had shown that it did not know that those stations were operating unlawfully. In relation to that, Tunein produced evidence that it did not know that the stations were operating unlawfully. That's in the supplemental bundle. Mr. Straley's evidence at page 182.
Can I just, before we get into the detail, I'm a bit puzzled by this. If the relevant scheme is not up and running within the relevant country, how can it possibly be operating?
Sorry, we're getting an echo that makes it difficult to hear Lord Justice Arnold. I think, Mr. Howe, last time you muted your microphone when listening to him, it made it better. Thank you.
Let me try again. I'm looking at what the judge said at 116. The relevant remuneration scheme is not yet up and running in the relevant state, no remuneration being paid. So if lawfulness depends upon an operating statutory scheme, and the statutory scheme in the country in question is not up and running and no money is being paid, how can there be any alternative conclusion other than that it's unlawful? And how could anybody think anything different? That's what's puzzling me.
Well, my lord, it's a slightly involved position because that's likely to be a reference, though the judge doesn't specify the country, that's likely to be a reference to the Canadian station, country 104, in relation to which the position appeared to be, on the evidence before the judge, that there had been a proposal by the relevant collecting society for a scheme covering webcasting and simulcasting. The scheme had been disputed and had been referred to the Canadian Copyright Tribunal or equivalent. And there was an issue of law which there was no clear determination as to whether, in those circumstances, pending the period when the Copyright Tribunal was considering the scheme, the operation of the webcasting and simulcasting was lawful. Because, as you know, when there's a proposed scheme referred, or an existing scheme referred to the Copyright Tribunal here, there are provisions that enable a potential licensee to pay the money and operate under the scheme and therefore receive immunity in relation to infringement, effectively as if they were operating lawfully. And that was the issue in relation to the Canadian. It's probably that issue that the judge was referring to briefly. It's dealt with, summarised in the evidence, in fact, quite briefly in the additional supplementary bundle, in a passage of cross-examination of Mr. Reckard, who's one of the claimant's witnesses, at page 5. It's page 181 of day 2, and at this point, Mr. Eckhart was being asked questions about the position in Canada. As one can see on page 181, the question summarises what appears to be the position by reference to Mr. Eckhart's evidence. You explain the current situation is that ReSound, which is the collecting society, has submitted a proposed tariff to the Canadian Copyright Board, but the board has not yet ruled on it. Correct. The result is not being possible at the moment for the relevant MLC, which is ReSound, to collect remuneration because it's awaiting approval. On that basis, correct. On that basis, you conclude country 104 as being designated as, in other words, unlicensed or not operating lawfully. And then I refer them to the definition we were using. And the question is, we agreed that simply non-payment is not what matters, but whether the station is operating lawfully or unlawfully. That's why we're using the expression not licensed. It doesn't follow that the station is not paying, that it's not operating lawfully. So that's a matter of interpretation, there's a statutory obligation, etc. And then turning to the Canadian system, ReSound has to collect the fees. Correct, it's mandatory, no one else is allowed to. That's right. At the moment, ReSound has a promulgation proposed tariff, not yet finalised, correct. It's your contention in these circumstances an FM station wants to exercise its simulcasting right and is unable to pay under a tariff is therefore operating unlawfully. To which the answer is, frankly, Canada is a very peculiar country in that respect, an outlier. As to the question, it's a very good legal question, you know, what is the status? Are they, if you will, in a legal limbo? Are they operating legally? What happens if after the promulgation of the tariff the station decides not to pay anything? Very good legal question, thorny issue, if I may say so. And he refers back to that. And the question continues on the same page about the fact that they don't have a tariff to pay under. So there's a strange position, a thorny issue, as Mr. Eckhart very fairly acknowledged in relation to Canada, which is there seems to be a situation where there's one body that is the designated body for collecting the tariff, it's proposed tariff, it's before the Copyright Board, and in the meantime, the issue under Canadian law is whether the stations are entitled to operate or not. The position is, though, however, that the relevant operator of Country 104 is a large and substantial reputable organisation which was paying substantial fees in relation to its copyright usage, although they're not broken down from their accounts in a way that
sorry, I thought you just made it clear by reference to this cross-examination that they weren't paying, and the point was they weren't able to pay.
Yes, well, Lord, it's unclear whether they're making provision or making payments, or making provision for their fees or making payments in some way or another, but they weren't able to pay the relevant body in relation to that tariff. So there was a strange legal limbo in Canada, which is, in answer to your Lordship's question, probably what the judge was referring to when he was talking about the scheme not being set up yet. There may have also been other territories in which the scheme had not been established for one reason or another, but that's the one that, on the basis of the evidence, it appears the judge is probably referring to.
Well, presumably the position must have been a bit clearer in relation to, let's say, Luxembourg. I mean, Luxembourg is an EU member state. So surely we know what the answer is there. Are you telling me not?
My Lord, I cannot at the moment recall exactly what the evidence was in relation to Luxembourg by the conclusion of the matter, because there was a debate between us about, as one can see, about who bore the burden of proving that the was unlawfully. And as the judge found in the end, he couldn't resolve it at that stage.
Yeah, but you see, if I may pursue this point, you see, these different countries fall into different categories. So we've got 2 that are EU member states, so they should be granting the rights required, not least by the Infosoc directive. Otherwise, they're non-compliant with EU law. And I don't know of any suggestion that as of this date, Luxembourg in particular was non-compliant with EU law. I mean, they would have been subject to infraction proceedings by the Commission. It hasn't happened. So we put those on one side. Then you've got Canada. I would have to check, but I would assume that Canada is a contracting state under the WIPO copyright treaty. But then you've got Kazakhstan, which I would assume is almost certainly not a contracting party under the WIPO copyright treaty. So we'll constantly lump these countries together. There are different considerations that apply.
Yes, quite so, which may be why the judge concluded it wasn't something he could resolve at this stage on the basis of the evidence before him. And just in answer to your lordship's questions, I'm slightly going on memory, and I may be mistaken. The juniors provided some information to me, which I think is probably right. But in relation to Luxembourg, the problem may have been that the scheme was in existence, rather the statutory provisions were in existence. But in order for the statutory provisions required the collective management organisation to be set up in Luxembourg to collect the royalties. And at the time of the trial, the relevant CMO had not been established. And therefore, the issue was, if the CMO hasn't been established, and the statute specifies that the CMO is the only entity allowed to collect the royalties, does that mean that no one can webcast or simulcast? Or are people entitled to webcast and simulcast on the basis that at some point they'll be required to account for the royalties? And well, there are other details in relation to the other jurisdictions. As regards Kazakhstan, that station fell away in the event because there was, perhaps unsurprisingly, no evidence it had played any of the relevant sound recordings. It seemed to be devoted entirely to Kazakh music that wasn't within the claimant's repertoire, which the judge mentions in his judgment. Yes, it's paragraph 159. There's no evidence. This is page 156 of the bundle, core bundle. There's no evidence the Kazakhstan station Gapku FM has ever played any relevant sound recordings.
Well, that's helpful, and I'm grateful for the explanations such as you've been able to give them. But I just wonder where all this takes us to, because you accept that there's a finding in relation to 2 stations, Capital FM Bangladesh and Urban 96.5 Nigeria, where there's a finding that they were operating unlawfully, and you don't challenge that. So why is that not a sufficient basis for the judge to proceed on, even if he's left the status of the other ones up in the air?
Yes. Well, 2 points in relation to that. The first is that he didn't leave, just starting with the second point first, he didn't leave the other ones up in the air. He made findings that even if one was applying the GS media presumption, that Tunein had not discharged its burden of proving that it didn't know that they were licensed and or that it ought not to have known. So he didn't follow through, probably forgot that he had decided in relation to all but 2 of the stations that it wasn't possible to make any determination in relation to those whether they were operating lawfully or unlawfully. Without that finding, there was no further findings that could be made in relation to those stations as to whether or not they were committing acts of, or rather that Tunein was potentially committing acts of communication to the public by providing hyperlinks to them, because it was a necessary precondition to that finding that they should be found to be operating unlawfully, and he decided he couldn't do that. In relation to the other two stations, which are the Nigerian and Bangladeshi station, he needed in relation to those to follow through the proper steps in relation to the presumption. In other words, he needed firstly to consider Tunein's evidence that it did not know that these stations were operating unlawfully, and consider whether that evidence was correct or not. If that evidence was correct, then it followed that he needed then to move to the next stage, which is Tunein, having established that it did not know, ought they have known in relation to those stations, which would have required considering what inquiries Tunein made in relation to those stations, and whether, if it had made those inquiries or other reasonable inquiries it should have made, it would have found out they were operating unlawfully. And he did not make any of those findings. As regards Tunein's evidence, one finds it was said in several points in the evidence, but if you turn the supplementary bundle to Mr. Straley's witness statement at page 182, which is tab 14, this was an extract from Mr. Straley's evidence in relation to the various stations, where he put in tabular form the position that, as well as Tunein knew what position was in relation to each station. Category 2, under radio Dudelanger, one can see that he's ticked update station form submitted and given the date for that. In relation to city, urban and capital and urban being the two other stations, there's a new update station form submitted, as one can see, in 2015 and 2016. Sorry, 2016, 2017. And then continuing on in the body of his evidence after that on page 185, he says at paragraph 74, for example, notwithstanding that Tunein did not believe that any of the sample stations we had nominated were unlicensed anywhere in the world, by letter they wrote stating, etc., that they thought they were nominated in category 3, but they would be treated as falling in category 2. And then at paragraph 76, he says, prior to receiving the letter from the claimant's attorneys on 12th July 2018, we were not aware of any allegations being made by the claimants or any other copyright owners in relation to the above stations. As can be seen, etc., each of these 8 stations have been indexed as a result of either submitting new station form or where they've been previously manually added and subsequently submitted an update station form, in the course of which they expressly indicated they accepted Tunein's terms and conditions. Now, I'll come on to the terms and conditions issue in a moment.
Is the point of having sample stations that they are samples and you decide the point about those samples, and from that you can then extrapolate that decision to lots of other stations in that category? And wasn't the sample 2, the category 2, supposed to be examples of stations which were not licensed in the UK and not licensed or free from license, but were unlawfully acting in their local authority, so that the judge could decide what is the legal position of that category of stations? But I don't see what, if you're right that you were meant to go into the individual situation of each of these stations, what's the value of having a sampling process? Because those then don't tell you anything at all about any other of 100,000 stations.
Well, there are two purposes to the sampling process, my lady. The first is obviously, as regards the generic legal issues, to provide a framework against which to decide the generic legal issues that might apply across the board, such as the scope of the communication to the public right and the sort of discussions we've had about how the correct understanding of the CJEU authorities. That's the first aspect of it. The second aspect of it was in relation to the factual position, to allow there to be specific factual findings in relation to the chosen sample stations, on the basis that, as provided for in the CCMC order, depending on the outcome of those debates and findings about those sample stations, whether further issues could then be decided. For example, it might be, depending on the nature of the samples, that particular findings in relation to those stations could provide guidance as to how one would approach the evidence in relation to the other stations. For example, one might have, if there had been findings that the Tunein knew that they were unlawful, that would be one thing. If the finding had been that they did not know, then the judge could have explored in relation to each station in those different territories what it is alleged that Tunein should have done under the ought to have known section in order to discover the status of the stations. So that was the purpose of the sample stations, to provide some confined factual framework against which, or confined framework against which to make particular factual findings. Now, inevitably, when one chooses a sample in those circumstances, it means that the factual findings will, in the first instance, will always be confined to that particular sample, but it may well be that the findings that are helpful in reducing the scope of the dispute, as the case may be, in relation to many other stations. And in any event, as I say, the resolution of the general legal issues, it was anticipated, would be helpful because it would establish the legal framework against which these matters were to be decided. So, that, however, didn't relieve the judge of the necessity of considering making the relevant findings in relation to sample stations, which, for the reasons I've explained, he didn't in the event do. There was evidence that Tunein didn't know that they were operating unlawfully. In relation to the stations he found were operating unlawfully, it was therefore necessary for him to consider whether that was right or not. It seems to be implicit that he accepted that Tunein didn't know. But then in relation to the two stations that were still in play, because the judge felt able to make findings that they were operating unlawfully, the next stage he should have gone to is to decide whether, on the evidence, Tunein ought to have known they were operating unlawfully in relation to those stations.
Sorry.
Well, I was just going to ask if that factual challenge is in your notice of appeal, isn't there? Well, it may be a convenient moment, unless my Lord Justice Arnold wants to put his question to give you a chance to think about that overnight.
Well, I just want to follow up what Lady Justice Rose was asking about. Because if we look at paragraph 113 of the judge's judgment, he sets out the four categories. And the point which my lady made, which at the moment seems to me to be a highly pertinent one, is that category 2 is defined as music radio stations which are not licensed in the UK or elsewhere. So if a sample station is nominated which doesn't fit that description, then the consequence seems to be simply it drops out of that category.
Yes, my lord, I agree. But there was, as you can see, there was a dispute about whether these category 2 stations were licensed or not. We didn't nominate any sample stations in category 2 because we didn't consider there were any unlicensed stations that we were aware of.
Well, Mr. Howe, I think I'm going to give you an opportunity to contemplate the factual question with the benefit of my lord's question. How are you doing for time? I think you're only in your 4th section, aren't you?
Yes, I'm currently in my 4th section, my lord. However, the remaining sections, now that I've been to the main CJEU case stall, should be considerably quicker. There's a little bit of authority on authorisation, but not too much. And your lordships and your ladyship, I imagine, will probably have come across it before. And then a certain amount on targeting, but again, that's more a question of, we don't in fact dispute the judge's summary of the targeting principles. We say that he got it wrong in the way he approached the facts, and that he didn't apply the relevant test in the targeting principles to the facts of this case. So that's relatively straightforward. So, my lord, I would have thought there's then the section in relation to the position after 2021, 1st of January 2021.
Well, how long is it all going to take, Mr. Howe? Are you going to be finished by midday?
Yes, my lord. I think I will.
Very good. Well, in that case, we'll adjourn now, resume at 10:30 in the morning. Thank you.